Good afternoon and welcome to the Banco Court. We have a meeting here today on land that by tradition is in the custody of the Toowoomba and the Yagara peoples. And they were the first people to make history here and undoubtedly the first to reflect upon it as we propose to do tonight. The child of a shoemaker in Newcastle upon Tyne, Sir Charles Lilley made his life and career here in Brisbane. He undertook articles here under Robert Little, including while he was editor of the Moreton Bay Courier. He was the first solicitor admitted to practice by the Supreme Court at Moreton Bay. That, of course, was the Supreme Court of New South Wales on circuit here. But he was called to the bar of this court in 1861 and appointed Queen's Counsel in 1865. Sir Charles rose to be Attorney General and then Premier of Queensland. He became a judge and then the Chief Justice of this court. And he had throughout his life an enduring interest in education. He was a towering figure in politics and in law in colonial Queensland. In October 1892, Sir Charles announced his intention to resign as the second Chief Justice of the Supreme Court of Queensland. The catalyst for this decision was his behaviour throughout a 57-day-long civil trial in the matter of Queensland Investment and Land Mortgage Co. Limited and Grimley. Tonight, we welcome Dr. Sarah McKibbin to speak about the Grimley affair. Dr. McKibbin is a lecturer in law at the University of Southern Queensland. There she teaches, researches and publishes in the fields of legal history and private international law. Dr. McKibbin is the lead author of A Legal History for Australia, published in 2021. Would you please welcome Dr. McKibbin?
On Thursday, the 31st of March 1892, the member for Toowoomba, Michael Gennon, moved a motion in the Legislative Assembly of Queensland that, in the opinion of this House, no judge should sit alone in court or in chambers in any matter in which his son acts as counsel. Gennon, a supporter of Sir Thomas McIlwraith, was quick to remind the Assembly of the Justices' Prevention Bill he introduced less than 2 years earlier on a closely related subject. Gennon's Justices' Prevention Bill of 1890 was modelled on a New York law and intended to prevent a barrister, solicitor or legal practitioner from appearing before a judge or a justice of the peace to whom he was related by blood of father, son or brother. The bill lapsed, but not before extensive and heated debate revealed its deeply personal nature. The parliamentary debates are scattered with references to the three Smiths, Smith and Sons, the Trinity, and the Father, Son, and Holy Ghost, referring to Sir Charles Lilley, the second Chief Justice of Queensland, and two of his sons, Barrister Edwin Mitford Lilley and Solicitor Charles Bertram Lilley. Edwin's continued successes before his father had encouraged gossip. So much so, it was thought litigants would stand a better chance of success before the Chief Justice if they were to engage one of the two sons of the Chief Justice. At least superficially, there was some merit to this argument. During the parliamentary debate in 1890, the member for Nunda, George Agnew, presented statistical returns showing the frequency with which Edwin appeared before the Supreme Court justices compared with other counsel over the previous 12 months. In the 980 cases before the Supreme Court over 1889 and 1890, Agnew reported that the son of one of our judges has appeared in the courts of this colony before him and other judges no less than 180 times. He appeared before the judges of this colony oftener than Sir S.W. Griffith, Mr. Reel, now Mr. Justice Reel, and Mr. Virgil Power combined. Agnew overstated the figure, but not by much. Between the 1st of July 1889 and the 30th of June 1890, counsel was employed before Lilley in 221 cases. And of those 221 cases, Edwin appeared before his father, the Chief Justice, in 157 cases, or equal to 72% of the whole, either alone in 108 cases or with others in 49 cases. In 1892, 2 years later, these concerns of impartiality resurfaced during the 57-day civil trial of Queensland Investment and Land Mortgage Company Limited and Grimley. Chief Justice Lilley was the trial judge, and Edwin appeared for the plaintiff company. The trial was well underway when Gennon moved his motion in late March 1892, and its timing did not escape the attention of the Premier, Sir Samuel Griffith, who could not disentangle the two. Griffith warned Gennon and every other honourable member who speaks upon this subject to be very careful. The matter was sub judice. Griffith was, in any case, firmly against the motion, saying, "The difficulty Gennon has referred to is a difficulty incident to a young country where the number of judges is limited and where the number of the profession is limited. It is a difficulty which will cure itself as time goes on." After months of deferrals, Gennon's motion was eventually adopted by 40 votes to 4. Griffith, of course, voted against the motion. But it was hardly possible to avoid talk of the Grimley case. The case attracted significant press attention in Queensland, intercolonially, and further afield because 4 of the 5 defendants, the Brisbane-based directors of the Queensland Investment and Land Mortgage Company, were individuals of high standing who dominated political life in colonial Queensland. Sir Thomas McIlwraith, Sir Arthur Palmer, Frederick Hart, and Edward Drury. Much has been written about McIlwraith, yet it is still worth highlighting how intricately connected these men were. Palmer, a pastoralist, had been Premier from May 1870 to January 1874. He was the leader of the opposition between 1874 and 1878. He served as Colonial Secretary and Secretary for Public Instruction between 1879 and 1881, resigning to become the President of the Legislative Council, a position he held throughout the Grimley litigation. He was also McIlwraith's brother-in-law and frequent business associate. McIlwraith had been Premier on 3 separate occasions, from 1879 to 1883, in 1888, and finally in 1893. He was an ex-railway engineer, pastoralist, and speculator. Late Queensland historian Bill Thorpe described the Palmer-McIlwraith alliance as arguably the most comprador yet most chauvinistic Queensland capitalist politicians to emerge in the colonial era. They either owned or controlled or directed many of the major non-domestic economic activities in this period: pastoralism, mining, timber milling, sugar production, banking, shipping, trade, finance, land speculation, railway construction, and the media. Edward Drury was the General Manager of the government-backed Queensland National Bank. Established in 1872, the Queensland National Bank held the government's account from 1879. The bank's successful tender for the government's business drew unfavourable comment. McIlwraith, one of its original shareholders, was a director. McIlwraith handed this role over to Palmer, his brother-in-law, and then Vice President of the Executive Council, ironically giving the bank more influence than it had before. The 4th prominent defendant, Frederick Hart, was a member of the Legislative Council. The identity of the trial judge in Grimley deepened the spectacle of having 4 individuals of high standing on trial. The trial judge, Chief Justice Lilley, had been at odds politically with Palmer and later McIlwraith. Prior to his appointment to the Supreme Court in 1874, Sir Charles had served in the Queensland Parliament from its inception in 1860 as the member for Fortitude Valley. He was Attorney General from 1865 to 1869, Colonial Secretary from 1869 to 1870, and Fourth Premier from 1868 to 1870. Arthur Palmer replaced him as Premier. This paper examines the Grimley litigation and considers the extent to which, along with Sir Charles's behaviour in other proceedings at the time, it brought into question his ethics as a judge. His behaviour in Grimley was, as the late Justice Bruce Macpherson put it, scarcely calculated to inspire confidence. The unusual circumstances of the case, described by Sir Harry Gibbs as a 19th century cause célèbre, prompted much-needed reforms to the structure of the Supreme Court of Queensland. I begin this paper with a sketch of Sir Charles's life, focusing on the final controversial years of his Chief Justiceship. My paper then gives an account of the colonial legal profession and the Supreme Court's composition. A brief overview of colonial land policy follows to provide the setting for the litigation in Grimley, together with its broader legal implications. In his biography of Sir Charles Lilley, the late Dr. John Bennett deplored that the Grimley case and the vilification heaped upon Lilley by political adversaries have been allowed to obscure his true stature. Sir Charles was, by any measure, an extraordinary man rising from humble beginnings to become one of the leading statesmen of colonial Australia. Lilley is particularly fated for the introduction of free education to Queensland, the first of the Australian colonies to do so. As Chief Justice, Lilley is credited with ensuring the successful application in practice of the judicature system in Queensland. Queensland was also the first of the Australian colonies to adopt the Judicature Act model soon after its enactment in England. Lilley's procedural flexibility as a judge won praise from the colonial legal profession. I do not seek to diminish these achievements. In this part, I therefore consider Lilley's life to the extent that it illuminates issues that arose during his tenure as a judge and which peaked with the Grimley litigation. Towards the end of his Chief Justiceship, Lilley had given politicians ample cause to dislike him, and his behaviour reflected unfavourably on the Supreme Court. In Sir Samuel Griffith's estimation at the time, the administration of justice in Queensland has fallen into contempt. Born in Newcastle upon Tyne in 1827, Charles Lilley arrived in Queensland in 1856 as a 29-year-old. Lilley completed his articles under Robert Lilley, a well-respected solicitor in the Moreton Bay district. He was admitted to the Supreme Court of New South Wales on Christmas Eve, 1858. In 1859, Lilley was elected to Queensland's first Legislative Assembly, winning the seat of Fortitude Valley by the narrowest of margins, 3 votes. Lilley held this seat until 1874. He was a radical Liberal, setting him apart from the squatter interests then dominating the Queensland Parliament. Lilley was admitted to the bar in 1861, taking advantage of a curiously drafted legislative provision he had a hand in introducing to Parliament. In 1865, he became the colony's first Queen's Counsel. The same year, he secured the position of Attorney General. Between 1868 and 1870, Lilley was simultaneously Premier and Attorney General. It was an eventful term in office for all the wrong reasons. As mentioned, Palmer succeeded Lilley as Premier in May 1870. Appointed to the Supreme Court in 1874, Lilley became Chief Justice in 1879, following Sir James Cockle's resignation as Chief Justice. Lilley was Chief Justice for the next 14 years. He was knighted in 1881. The early years of Lilley's Chief Justiceship were relatively uneventful, with Bennett characterising Lilley as a model of decorum, incisive in his command of the law and its practice, the president of a learned and compatible bench of judges, and greatly esteemed in his office by the legal profession. As the 1880s progressed, however, Lilley had grown restless as simply Chief Justice, longing for a return to political life. Lilley's behaviour, both on and off the bench, came under increasing scrutiny. In January 1888, a formal dinner at the Queensland Club descended into drunken revelry, with Lilley scandalising the visiting Earl of Carnarvon by providing the after-dinner entertainment, to quote, a mock trial of one and a sentence of death pronounced by him. So during the 1880s, he had developed a reputation for hard drinking. But Lilley's frustrations with his position were fermenting as early as 1881. On the 23rd of May 1881, he was invited to accept the dignity of Knight Bachelor, the lowest form of knighthood, but the one ordinarily conferred on many, not all, subsequent Chief Justices in Australia. After 2 days' consideration, he sent his enthusiastic acceptance to Governor Sir Arthur Kennedy. By the 27th of May, Lilley had second thoughts, pleading with the Governor's private secretary to take the knighthood back and telegramming the Governor to decline the honour. Governor Kennedy was naturally bewildered by Lilley's about-face, but left things as they were. In June, Lilley wrote a private petition to the Queen to grant him permission to relinquish the said dignity of knighthood, sent under covering letter to the Governor. In his petition, Lilley recited his 21 years of public service in Queensland. He understood that the dignity of knighthood has been conferred upon him by reason of his present tenure of the office of Chief Justice and has no relation to actual service. That was the nub of Lilley's complaint. The knighthood was a recognition of the office of Chief Justice, not an acknowledgement of him and his public service to Queensland. Sir Robert Herbert, Under Secretary of the Colonial Office and first Premier of Queensland, on reading Lilley's petition, perceived the vanity at work for which Lilley had a bad reputation. Herbert noted, the Chief Justice no doubt is foolishly offended at finding Sir A. Palmer, who has recently received the KCMG and is junior to him as a politician, has received a decoration which gives him precedency as between the two knighthoods, though the Chief Justice as such retains actual precedency. Now, Governor Kennedy could have placed Lilley's petition before the Queen. To his credit, Kennedy gave Lilley an opportunity to reconsider, assuring him that the knighthood was recommended because of, to quote, the eminent public services rendered by him before he attained to his present high office. Now, Lilley was left with no other choice but to retain the knighthood. Criticisms of Lilley in his capacity as Chief Justice, not all of which were justified, intensified as the 1880s progressed. In 1884, Lilley received public backlash for imposing long and severe sentences for the kidnapping and murder of Pacific Islanders by crew members of the Hopeful, a schooner used to recruit labour to work on Queensland's sugar plantations. During the Hopeful trials, Lilley courageously declared that all lives were protected and equal in the eyes of the law. If an English subject took a life, whether that of a white, black or yellow man, he was answerable for it. Subsequently, Lilley resisted the executive efforts to mitigate the men's sentences, prompted by a series of petitions seeking the prisoner's release. In responding to the petitioner's allegations, Lilley observed not a tithe of the persons who have signed this document could possibly have heard the cases, seen the anxiety and care with which they were tried, observed the demeanour of the witnesses, or even read the evidence in the journals of the day. The petition is mainly the outcome of the last election and is an attempt to rule the administration of justice by popular clamour. Another unjustified criticism of Lilley occurred 2 years later in 1886, when John Merter Macrossan extraordinarily used parliamentary privilege to allege that Lilley had defamed him from the bench in McSharry and O'Rourke. Wisely, Lilley did not respond publicly. Ill-advised comments from the bench also led to strained dealings with the executive. In October 1888, Lilley was rebuked in Parliament for comments he made as President of the Elections Tribunal, by which he quite correctly asserted the tribunal's independence from the Legislative Assembly. Lilley had directed the shorthand writer to take the evidence as a continuous narrative, which was the English practice, rather than the usual question and answer format adopted in Queensland. The Speaker of the Legislative Assembly, Albert Norton, objected. Lilley's reply in the tribunal emphasised its independence. I have received an intimation from the Speaker that neither he, whoever he may be, nor the House are satisfied with the taking of the evidence in that narrative form. I will receive no directions from the Speaker nor from the House in this court. The assessors are only judges here with myself, and I shall sit on no tribunal in this country under the direction of any man. Viewing Mr. Speaker Norton's interference as improper, Lilley warned that if Norton persisted, he would regard it as a contempt of court, as there he had all the powers of a Supreme Court judge. Colonial Secretary Moorhead regarded it as an insult to Mr. Speaker Norton, warning, the sooner the judges of the Supreme Court understand their position, the better. Moorhead continued, if this perversion of his high position is to be continued by that gentleman, we can clip his wings, he cannot clip ours. If the relationship between Lilley and the government was already prickly, the full court's 1889 decision in Burns and James would have done little to mend fences, even if it was the government rather than Lilley at fault this time. The dispute turned on the appointment of a taxing officer, Baines, to the Supreme Court without the judge's consultation. The government had created the new office under Section 39 of Queensland's Supreme Court Act of 1867, but ignored that part of Section 39 which read, no new office shall be created in the said court unless the judge or judges thereof shall certify by writing under his or their hand or hands to the said governor that such new office is necessary. The Supreme Court judges had not given their certificate. When Baines taxed a bill of costs in Burns and James, Harding questioned the validity of Baines's appointment and referred the question to the full court. Andrew Tyne, the Minister for Justice, made matters worse by writing a minute on the file that was then seen by the justices. Why has not this been reported by the registrar since it arose? Baines does not hold any separate or independent office, and his taxation is subject to reference in respect of disputed items to the registrar from whose decision a review might be applied for. The judges were agreed that a so-called taxing officer has been appointed irregularly and illegally. Lilley remarked if the independence of the officers of the court can be interfered with, if they can be withdrawn from the control of the judges, and strangers can be foisted into the offices of the court, the independence of the judges would be at an end. And by carrying out the behests of the political executive, other than the judges, the officers of the court might become a political engine of injustice. But it was Lilley's extrajudicial pronouncements on controversial public issues that caused the most disquiet. Between 1890 and 1893, Lilley increasingly offered his views on social and political causes, universal education, women's suffrage, and the Republican movement for wider public consumption. These views, now relatively uncontroversial, were radical. Most extraordinary of all was Lilley's interview with the Pall Mall Gazette, published in January 1892, calling for Australia to become a republic. Lilley considered it to be his right, even as Chief Justice, to comment on public matters. In an open letter supporting the Labor candidate Charles Fitzgerald in the Bulimba by-election in April 1892, Lilley, still the Chief Justice, explained that his position did not preclude him from the exercise of any right of citizenship, so long as I assert it fairly and without bitterness. Conscious that this opinion may make other people hate me, Lilley did not consider it a sufficient reason for withholding my voice or pen from helping a good cause or fulfilling a duty. Now that brings me to the state of the colonial legal profession during the Grimley litigation. Late 19th century almanacs reveal the close-knit nature of the legal and political establishment in colonial Queensland. In 1891, Queensland had a population of 393,718, the result of the colony's highly successful immigration policies following separation. Now, the colonial legal profession was unsurprisingly small, making it more probable than not that a barrister might appear before a relative on the bench. The 1892 edition of Pugh's Almanac and Queensland Directory records 81 barristers on the roll, many of whom were absent from and so not actually practising in Queensland. Approximately half of those listed, 49%, were practising at the private bar, 35 in Brisbane and 5 in Townsville. 11 barristers, 10 of whom practised in Brisbane, were briefed by the parties in the Grimley case. One was Edwin Lilley, another, Patrick Reel, was elevated to the Supreme Court bench. 5 judges occupied the Supreme Court bench, increased from 4 by the Supreme Court Act of 1889. 2 judges, Cooper and Chubb, were styled Northern judges, sitting in the Northern Supreme Court in Townsville. Before 1889, the Northern Supreme Court sat in Bowen. The remaining judges, Lilley, Harding and Reel, were located in Brisbane. The full court heard appeals from the decision of a Supreme Court judge. Under the Supreme Court Act of 1874, the full court shall be holden by and before 3 judges, but where one could not attend, 2 judges were permissible. Between 1874 and 1885, it was not uncommon, as Macpherson noted, for the full court to comprise only 2 judges. The judge who gave the decision appealed from could theoretically sit on the full court. Before 1892, Northern judges were precluded from sitting in the Southern Division of the Supreme Court and on the full court because of the full court's judgment in Mr. Justice Shepherd's claim. In this decision, Lilley, in delivering the full court's judgment, rejected Shepherd's claim to the position of senior puisne judge resident in Brisbane following Lutwycher's death in 1880. Both Lilley and Shepherd were appointed to the Supreme Court in July 1874. Shepherd became the inaugural Northern judge, demanding his relocation from Brisbane to Bowen. He accepted the appointment, he said, on a distinct promise that he would become senior puisne judge, entitling him to return to Brisbane. In the interim, 2 further judicial appointments had taken place: George Harding in 1879 and Ratcliffe Pring in 1880. Harding and Pring were resident in Brisbane. If the full court accepted Shepherd's claim, he would be senior to Harding and therefore entitled to sit in Brisbane. Pring, who had just been sworn in when Shepherd made this claim to the full court, would be sent north. Lilley found that following the 1874 Act, the Supreme Court had been divided into 2 branches. He said there was a staff, so to speak, of 3 judges acting in the Southern Division and another staff of 1 judge in the north, acting within a jurisdiction to be assigned to him by the Crown. Based on Lilley's interpretation of the 1874 Act, the senior puisne judge was the senior puisne judge of the court holden at Brisbane, which was Harding. Effectively, Shepherd's jurisdiction was limited to the Northern Supreme Court and he was ordered to return to Bowen. The Northern judge's inability to sit in the Southern Division or on the full court became a significant issue in the Grimley case. The Queensland Investment and Land Mortgage Company Limited was incorporated in London in 1878 to raise money on the security of lands in Queensland. Initially, McElwraith, Hart, Drury and Sir Joshua Bell acted as local directors. Following Bell's sudden death in 1881, Palmer was appointed. The four men were natural choices to constitute the local board of directors because they knew the value of colonial land. At the time of the company's establishment, Queensland's outlook seemed glittering and safe. By 1888, the colony's prosperity was no longer assured. Drought conditions prevailed in the 1880s, resulting in a depressed economy and shrinking company dividends. At the company's annual general meeting in London in July 1888, shareholders criticised the manner in which business was transacted out of the Brisbane office. The general sentiment was that the local Brisbane-based directors had too much control. The chairman, Mr. Martin, reassured the shareholders that the board was not to lend more than 50% on their own independent valuations of any property. In early September, on receiving reports of the meeting, the four Brisbane directors cabled London, tendering their resignations. The company, now starting to question the value of its securities, dispatched its general manager, Reginald Finlay, to investigate the true state of the company's colonial affairs. Following these investigations, the company issued 7 writs against various defendants on the 26th of November 1888, claiming a total of £250,000. The first writ was against the former storekeeper of Jimbour Station on the Darling Downs, Samuel Grimley, and the 4 local directors of the Queensland Investment and Land Mortgage Company. Grimley obtained advances from the local directors on the security of now repossessed lands on the Darling Downs. The plaintiff company claimed around £63,000 for advances made to Grimley with interest. The remaining 4 defendants were sued for negligence and malfeasance for advancing money on insufficient security. Leading counsel of the day were briefed Sir Samuel Griffith, Edwin Lilley, Alfred Payne and John Woolcock for the plaintiff, Arthur Fees and Arthur Rutledge for Grimley, and Solicitor General Burns, Virgil Power, William Shand and James Benatine for the remaining defendants. Lilley's most significant biographer, Bennett, speculates that Lilley may have tried to persuade Griffith to take Edwin Lilley's place, to spare Edwin from the unpleasantness that seemed certain to occur and which did occur in the course of the trial. At any rate, Griffith withdrew to form the so-called Griffle-Wraith coalition with political foe McElwraith, and Payne, by this stage tubercular, relinquished his brief. Samuel Grimley had selected lands comprising 3,144 acres in the Bunya Mountains and 15,827 acres of Crown land, formerly part of Jimbour Station, owned by the Bell family. Grimley was intimately connected with the Bell family. Once Jimbour storekeeper, formerly secretary of the Darling Downs and Western Land Company, and accountant for Bell and Sons. Before his death in 1881, Sir Joshua Bell established the Darling Downs and Western Land Company to separate ownership of the stately Jimbour House from the station and to merge the pastoral holdings of the Bell family, long-term Darling Downs squatters, with those of McElwraith and his business partner Smythe. Squatters were among those who agitated for Queensland's separation from New South Wales in 1859. The colony's new constitution defended conservative pastoralist interests, yet the squattocracy's dominance would gradually subside following liberal land reforms. These reforms halved pastoral leaseholds to enable closer settlement. Squatters used various stratagems, such as dummying, to regain control of land resumed by the Crown for selectors. Dummying was the practice of selecting land, fulfilling the Crown's conditions of purchase, and then transferring the land back to the squatter for nominal consideration. Allegations of dummying were advanced at a very late stage in the Grimley trial. After 3 years of interlocutory proceedings, the defendant sought a civil trial before a judge and a special jury of 12 in September 1891. The plaintiff company sought trial by judge alone. A trial with a jury of 4 businessmen was ordered. In making this order in chambers, Lilley reserved leave to himself to discharge such jury and to try the said actions or either of them without a jury, if at such trial he should see fit so to do. While the plaintiff could select the judge before whom their case would be tried, that did not in any event matter. Lilley was the only judge who could try the action and hear any appeal. His 2 brother judges in Brisbane stood down. Harding's second wife was the sister-in-law of Drury, one of the defendants, as well as a shareholder in the Queensland Investment and Land Mortgage Company. Real, meanwhile, had been briefed by the plaintiff company and advised on the case before his elevation to the bench, and as we know, the 2 northern judges were ineligible to sit in the southern division. The local press offered a blow-by-blow account of the trial, which commenced on the 5th of November 1891. At the trial's opening, Grimley offered to submit to judgment for the principal sum with 7% interest. The plaintiff company refused, claiming 9% interest. On the trial's 5th day, the Chief Justice advised counsel for the plaintiff company and the defendants, excluding Grimley, that he intended to act on his reservation and try the case himself. Solicitor General Burns, acting for the local directors, objected. The trial resumed until the end of the year's sittings, recommencing on the 15th of February 1892. On the 37th day of trial, Edwin was granted leave to amend the statement of claim to present an entirely new case. As Macpherson pointed out, this was in defiance of accepted legal practice. The new case asserted that the securities were not only insufficient but worthless as well. Specifically, Grimley was not a bona fide conditional purchaser of land under Queensland's Crown Lands Alienation Act of 1876, but a dummy purchaser for the estate of Sir Joshua Bell or the firm of Bell and Sons. A chamber application to strike out the amendments as embarrassing, irrelevant, and tending to prejudice and delay the fair trial of the action was dismissed, with costs against the defendants, except Grimley. The defendants demurred to the amended statement of claim, and the Chief Justice ordered that it stand over until motion for judgment. A lengthy adjournment allowed the defendants to amend their pleadings, with the trial resuming on the 9th of May. On Thursday, the 19th of May, the Chief Justice summed up and submitted 143 questions to the jury. The jury returned 2 days later with their verdict. While not answering every question, nor agreeing on some, what answers they provided favoured the 4 leading defendants in 3 respects. First, the local directors had exercised proper care in their dealings. Secondly, the advances were given on good and sufficient security. Thirdly, all material information about the transactions had been supplied to the London board, and the London directors had acquiesced to the local directors' actions. They also found that Grimley had agreed to pay 7, not 9% interest. It will be recalled that at the trial's opening, Grimley offered to submit to judgment for the principal sum with 7% interest. All questions concerning dummying were marked not agreed to. The Chief Justice discharged the jury. He subsequently asserted that they could not agree. The Chief Justice adjourned the hearing of the cause and motion for judgment, reserving to himself the right to try the case. At a further hearing on the 18th of July, motions for judgment were presented. Despite the repeated objections of the Solicitor General, the Chief Justice reiterated his entitlement to try the case himself. The next 4 days were occupied by further legal argument. On Tuesday, the 16th of August, the Chief Justice delivered his judgment. The Queenslander reported that the courtroom overflowed with the principal businessmen of the city and many legislators, barristers, solicitors and clergymen ready to hear Lilley's judgment. The Chief Justice started his judgment by overruling the defendant's demurrers. He thought the amended statement of claim raised good legal issues under the Crown Lands Alienation Act of 1876. Judgment was awarded to the plaintiff company on the greater part, almost the whole of the case. Grimley was liable for the principal sum with interest at 7%, while the remaining defendants were also liable. Lilley outlined his entitlement to go behind the jury's findings, where the jury have failed to find the vital issues on which the final judgment in the action depends, and more especially where there is no reasonable expectation of better results from a trial before another jury. He concluded that the lands were illegally obtained, that the defendants knew they were so gotten, that they committed breaches of duty in taking them as securities and in advancing the plaintiff company's money on them, that the defendants were reckless and careless and did not act solely with a view of the interests of the plaintiff company. Predictably, the defendants appealed within the week. Only the local director's 2 grounds of appeal are relevant for present purposes. The first ground was that the Chief Justice should not have allowed the late amendments. The second ground was that in making the jury order, the Chief Justice could not reserve to himself leave to discharge the jury and to try the action himself without a jury if, at such trial, he thought fit to do so. Now, very fortunately, Griffith had the foresight to introduce legislation in the event of an appeal. The Supreme Court Act of 1892, which came into force in April of that year, eliminated the twin problems of the Chief Justice sitting on the appeal from his own decision, still a possibility, and constituting an appeal court of 3 judges. Lilley, outraged by these amendments, indicated his intention to resign in April 1893. The 1892 statute resolved these problems in 5 ways. In the first place, a judge was precluded from sitting upon an appeal from his own judgment. There are few reported instances of Lilley participating in full court hearings of appeals from his own first instance judgments. Secondly, 3 judges were to sit on full court hearings. Thirdly, Northern judges were competent to exercise in any part of Queensland all the jurisdiction, powers and authorities of a judge of the court, including authority to sit as a member of the full court. Fourthly, contested chamber applications, originally conducted behind closed doors, were to be adjourned into open court. Griffith had managed to convince Edwin not to appear in contested chamber applications before his father at the same time that this Act was passed. Finally, under Section 12, the Executive Council could appoint a District Court judge or any person qualified to be a judge of the Supreme Court to act as judge. Using this provision, Griffith intended to borrow a judge from New South Wales. In August, Griffith invited Sir Frederick Darley, the Chief Justice of New South Wales, to sit on the specially constituted full court in the Grimley appeal. Darley declined, but proposed Sir William Windeyer instead. Windeyer, senior puisne judge of the Supreme Court of New South Wales, accepted Griffith's invitation subject to the passage of a second Supreme Court Act of 1892. There were doubts that the wording of Section 12 was sufficient to allow the appointment of an intercolonial judge. The second Supreme Court Act of 1892 confirmed any judge of the Supreme Court of any of the Australian colonies may be appointed to act as a judge of the Supreme Court of Queensland, and any such judge shall be deemed to be a person qualified to be a judge of the court. The Act was assented to on Tuesday, the 13th of September. Windeyer arrived in Brisbane that morning, 2 days before the appeal was to commence. His swearing in the following day was reportedly a popular occasion with the court, as reported by the Brisbane Courier, literally packed with the general public, the attendants including many prominent men, ministers of the Crown, politicians, clergymen and others. There were a few ladies present, and the gallery of the court was also filled. On Thursday the 15th of September, the appeal was heard before Windeyer, Cooper and Chubb. Solicitor General Burns, leading Virgil Power, and William Shand appeared for the appellants. Edwin and Woolcock represented the respondent. On the 12th of October, Windeyer took 2 hours to deliver the full court's judgment. The judgment set aside Lilley's original judgment, restored the jury's findings, and found for the defendants other than Grimley. The full court criticised Lilley's reservation to try the case himself as without precedent or warrant of law, noting the consequences which might follow on a judge assuming the right to try a case concurrently with a jury are such as might lead to a travesty of justice too grotesque to allow of contemplation as a mere possibility. They continued their criticism of the Chief Justice's unprecedented course, which he adopted in setting aside the findings of the jury, trying the case himself, and giving judgment upon a set of findings of which counsel was entirely ignorant. Neither considerations of time nor of expense can be weighed in the balance against the duty of acting according to law and maintaining those recognised methods of procedure which experience has taught us are necessary to secure the uniform and even-handed administration of justice. Experimental shortcuts to justice, even if laudable in intention, too often result in the mere illustration of the proverb, the shortest cut is often the longest way around, to make them safe for adoption in the administration of the law. The full court could not imagine a better case for determination by a jury of businessmen, for it involved no such subtlety of reasoning or complexity of facts as made it more desirable that it should be considered by a lawyer with a legally trained mind rather than by laymen of intelligence. Who better to judge the value of securities fluctuating from time to time under the influence of droughts and periods of commercial depression than a jury constituted by businessmen? The jury had in fact answered the questions with singular correctness and displayed an amount of discrimination and acumen rarely exhibited by the best of juries, but which was to be expected from a jury of businessmen. The result stung. On the 24th of October, Lilley sent a formal resignation to Griffith, the Premier, with effect from the 13th of February 1893. His resignation was accompanied by a certificate from 3 Brisbane medical doctors who certified that Lilley was suffering from anaemia, impaired nutrition, weak action of the heart, and general exhaustion. His doctors advised that he was unable to discharge any judicial duties for the next 4 months. Lilley requested an immediate leave of absence on account of ill health, going on an extended holiday with his long-suffering wife to New Zealand. On his return in early 1893, Lilley confessed to the reporter, "Thank God I am free now. For 19 years I have served as a judge and I'm still bound by many things, but I have satisfied my own conscience and intellect, and there it rests with me." On the one hand, Lilley's resignation was almost inevitable following the full court's reversal of his judgment and press criticism. There may have been other motives for his resignation. It was rumoured that the Legislative Assembly intended to finally clip his wings by passing a motion to remove him from office. An incensed McElwraith, one of the defendants, had also started to make inquiries into Lilley's early life, as well as the embarrassing circumstances surrounding the conferral of his knighthood in 1881. McElwraith would receive the results of these inquiries into Lilley's early life the day after Lilley tendered his resignation. The report alleged that Lilley, as a young articled clerk in London, had misappropriated his master's funds, for which he was dismissed, but that he subsequently repaid the money stolen. Bennett dismissed this report as a tissue of malicious nonsense. He also considered the related theory of McElwraith forcing Lilley to resign by threatening to expose these youthful indiscretions as unlikely. But I think it stands to reason that McElwraith may have had some forewarning of the report's contents, even if he had not yet received it in full. On the other hand, Lilley had not enjoyed the best of health and always intended to retire in April 1893. On the 13th of March 1893, Griffith was appointed Chief Justice of Queensland. Griffith, suffering financially following a failed mining speculation, would have refused the office at its existing salary of £2,500. If it meant leaving his beloved Merthyr house to quote, go and live very quietly in a small house. On his own account, he was left with no choice but to accept when Parliament increased the Chief Justice's salary by £1,000 to £3,500. From what we know of Griffith's subsequent judicial career, it is difficult to imagine that this was his only reason for accepting the position. In retirement, Lilley attempted to re-enter politics. In 1893, Lilley contested the seat of North Brisbane against McIlwraith, and he lost. Lilley died in 1897, survived by his wife and all of their 13 children, 8 sons and 5 daughters. 7 of his eight sons became lawyers. Lilley had served as a judge for 19 years, 13 years as Chief Justice. Griffith considered Lilley's greatest legacy to the Supreme Court to be his procedural flexibility. In paying tribute to the late Chief Justice in 1897, Griffith said, "Every court comes to have an atmosphere of its own. I say with some knowledge of the procedure of other courts that this court may be said to be distinguished by its freedom from technicalities. I do not mean in its written procedure, I mean a tendency to go straight to the merits of a case, apart from technicalities. And the more I sit here, the more I am impressed with the fact that this tendency, which is most conducive to the fair administration of justice, is to a very great extent the result of the influence of the late Chief Justice." While his procedural flexibility had certainly won praise from the profession, Lilley was, above all things, held in high esteem by his judicial colleagues. On succeeding Lilley, Griffith brought up the kindness he had always received from Sir Charles Lilley, though never formally his pupil. Justice Pope Cooper eulogised Lilley for his abounding personal liberality and generosity. Lilley was always ready to extend a helping hand to anyone struggling or in need, and his hand always contained grain and not chaff. As Chief Justice, Lilley proved that he was no shrinking violet. He resisted the executive's efforts to mitigate the hopeful prisoners' sentences in the face of strong, racially motivated public criticism. At times, criticisms of Lilley as Chief Justice were unjustified, such as when McCrossan used parliamentary privilege to allege that Lilley had defamed him from the bench. At other times, Lilley's judicial comments further strained the Supreme Court's relations with the executive. Lilley's judicial legacy nevertheless remains mixed. His consistent refusal to recognise he was in a position of conflict was a growing problem during his judicial tenure, to the point that in Grimley it was plainly unacceptable. His most significant biographer, Bennett, was prepared to forgive Lilley's lapses in the Grimley case when his contemporaries could not. Griffith attempted to soften these criticisms, but he seems in substance to have agreed that Lilley was too often in a position of conflict. Even though he publicly defended Lilley, Griffith quietly attempted to resolve the problem. He prevailed upon Edwin not to appear before his father in contested chamber applications. Lilley's conduct in the Grimley case cast a long and deep shadow on a lengthy and otherwise successful judicial career. It led the Honourable John Dowsett in 1998 to observe that, as a judge, I would have welcomed Lilley's appointment as Chief Justice. Regrettably, had I been a judge at the time, I would also have welcomed his departure.
Dr. McKibbin, you really do combine two quite distinct and important areas of skill: an understanding of the law, but a really close and careful eye to history, and you have given us today really, I think, quite an astonishing tour through a very interesting period of the history of this state and of this court. And there are so many things that you've uncovered and I think presented in a way that makes the story both memorable but also very interesting. So thank you very much for that. I'm reminded in an odd way of, I think, what is Robert Downey Jr.'s best movie called The Wonder Boys from the year 2000, and the soundtrack, which was done by Bob Dylan, the main song of which is called Things Have Changed. I hope that is in some respects the case. But could I ask you all to join with me again to thank Dr. McKibbin for that tremendous presentation. It only remains for me to thank the Chief Justice for making this room available to us for this evening's presentation, and to invite you all to join us outside for some refreshments. For your own part, Dr. McKibbin, I hope you will accept the gesture that we have for you. It bears very little relationship to all of the work that must have gone in to the presentation of that paper. But thank you once again. Please join us outside.